Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and today's video is another in the series we've entitled Overconfident Sellers plus Overeager Buyers equals Broker Liability. And today's topic focuses on a discussion of the weaponization of earnest money. Earnest money was originally created as a concept in our industry to motivate buyers to exercise good faith in closing the transaction. Buyer puts up this chunk of money and says to seller, it's going to take me a little while to generate financing. Seller, you're going to have to go out and clear title of the property. So from the date of the purchase and sale agreement until the time we can actually close the transaction, I promise to exercise good faith. Here's a chunk of money to support or to show the earnestness of my intentions. That's earnest money. What we're seeing in today's marketplace is listing brokers and sellers actually using earnest money, if you will, as a punishment or a weapon against buyers who dare to purchase sellers' property, but between the time of the purchase and sale agreement and the time of closing, anything that goes wrong in that transaction doesn't close. Buyer, your punishment is that you're going to give up your earnest money no matter what the reason was that closing didn't occur. Now, let me just tell you right now that in this discussion, I could care less if you want to refer to earnest money as a deposit or by any other label. When I teach this topic, brokers always want to raise their hand and say, well, let's not call it earnest money. Let's call it a deposit, or let's call it a fee, or let's call it whatever you want to call it. I don't care. That's a distraction. The problem is buyer is taking a chunk of their money and saying, here, I'm going to put this money at risk, and if I don't perform in good faith, seller, you can have the money. But instead, in our marketplace today, listing brokers and sellers are creating a scenario where buyer puts up that money in good faith and seller says, I'll just take it now. And then regardless of what happens, I'll take it now and I'll keep it. Okay, so let's talk about a couple of examples where this is really proving to be a serious problem in our industry. Brokers are drafting purchase and sale agreements and labeling earnest money as non-refundable, or deposits, whatever you want to call it. They're labeling it as non-refundable, and then writing the purchase and sale agreement to include a financing contingency, an inspection contingency, a title review contingency, whatever the contingency may be. And maybe a really savvy broker writes the non-refundable provision to say that the money becomes non-refundable after buyer's satisfaction or waiver of the inspection contingency. But remember that under our statewide form system, the buyer's financing contingency persists all the way to closing unless seller forces a waiver of that financing contingency, which quite frankly, most listing brokers aren't empowering their sellers to do because most listing brokers across the state aren't helping their sellers to utilize either paragraphs 2 or paragraphs 3, the loan information and the notice of right to terminate in the financing contingency that buyer puts into the transaction. That's the subject of a different video. If that financing contingency is allowed to persist all the way to closing, then we get to the closing table and buyer has both a financing contingency and a non-refundable provision. Or maybe the financing contingency isn't the issue. Maybe the buyer had a 22T title review contingency and days before closing an amended title policy came out that gave buyer a renewed right to terminate the purchase and sale agreement based on the title review contingency. In any event, we get to closing and we find out that buyer can't close the transaction and buyer has the benefit of, let's just say, the financing contingency. Buyer gets their paragraph 5, Form 22A, paragraph 5 letter from their lender justifying release of the earnest money to buyer based on the terms of the financing contingency. And we have this non-refundable provision. Now, who gets the earnest money? We have one chunk of money, and we have a buyer who's entitled to it because of the financing contingency, and a seller who's entitled to it, theoretically at least, based on a non-refundable provision. Who gets it? Sadly, for the brokers involved in this transaction, if it goes to court, probably both the buyer and the seller are going to get it. Now, who's going to make up the difference in that earnest money, since there's only one pot of earnest money and two parties are both entitled to it based on the drafting of the purchase and sale agreement put in place by the brokers? You got it. The brokers are probably going to be liable for that. Why? Because as brokers, you're held to the standard of care of a lawyer when you draft a purchase and sale agreement, including when you incorporate two conflicting provisions. And when you have a contingency that benefits the buyer and a non-refundable provision benefiting the seller, they can't both occur And so when the transaction fails to close and they're both entitled to earnest money, there's a conflict, and a court's likely to resolve that by saying, broker, you get to write the check for the earnest money that's missing. Okay, set that aside. Not that we've resolved that issue. That's still a very relevant issue, but let's talk about another one that's just as big of a problem. In today's market, we are seeing more and more and more opportunities where listing brokers and sellers are saying, hey, not only is the earnest money non-refundable, but to save the fight later over me having to try and collect it, I just want it now. So buyer, if you want to be able to buy my property, then you just need to write a check for a chunk of money and write that check payable to me, the seller, immediately. Sometime prior to closing, seller is going to get a chunk of buyer's money just because this is the buyer in the transaction. And then when we get to closing, if the transaction can't close, really regardless of who's at fault, seller's already got buyer's money. So let's look at a few examples. First of all, remember that the boilerplate language of the purchase and sale agreement says that seller must provide marketable title at closing. Okay, here's the email I've gotten on the hotline countless times over the last few months. Days before closing, seller was incapacitated. Car accident, illness, whatever it was. Days before closing, seller actually passed away. Days before closing, it was revealed that seller was actually in foreclosure. When the preliminary commitment was pulled, the foreclosure wasn't yet revealed on title. Now, days before closing, it is revealed. Seller's lender hasn't cooperated in providing a payoff. We don't have seller's payoff, so we can't satisfy the title and escrow requirements for generating marketable title. Or the one that honestly I've received more than any other in the last few months is that seller simply changes their mind and they no longer want to close the transaction. Why? Because this seller, who has now sold their property and re-enters the marketplace not as a seller but as a buyer, realizes how tough the marketplace is as a buyer and says, hey, I can't find anything else to buy, so I changed my mind. I don't really want to sell my house after all. And all of a sudden says, not closing the transaction. Now, in any of those circumstances, either seller can't or won't provide marketable title, and that's the reason buyer can't close the transaction. Who would not agree that buyer should get the money back, their earnest money back in that situation? But the money has already been released based on your drafting of the purchase and sale agreement. Money has already been released to the seller. Brokers, I challenge you, go get that money back from that seller. In the case where seller was either incapacitated or passed away before closing, the money was absorbed into that seller's finances already. Somebody else is now controlling their finances, a guardian or an estate. How are you going to get that money back? Or the situation where the seller's in foreclosure, that seller obviously doesn't have a lot of money. How are you going to get the money back from them? Or even the seller who simply changed their mind. Go get that money back, brokers, because you know what? You're going to have to. Because you're the one who, acting with the standard of care required of a lawyer, drafted a purchase and sale agreement that said two separate things. Money's going to be released to seller prior to closing, but seller still has to provide marketable title. And if seller can't provide marketable title, the purchase and sale agreement says buyer gets their money back. Except for that, as an industry, we weaponized earnest money and said to the buyer, oh, don't worry about the protections that you're offered in the purchase and sale agreement. You're going to pay seller just to be the one who gets to have your name appear on a purchase and sale agreement as the buyer. It's a risky approach, brokers, that we as an industry are taking with respect to this issue. And I challenge you, don't do what everybody else is doing just because they're doing it. Think critically through this issue. You have a duty to represent your buyer's interest in the transaction and to act with the standard of care of a lawyer in drafting a purchase and sale agreement. If you have questions on this topic or any other, and I know this one is challenging, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.